Hello and welcome to another Tuesday tip. I'm Pam Keslauskas, and today we're going to be talking about HUD's new notice. So, starting the year off with a new notice, or ending the last year with a new notice, on December 13th, 2024, HUD published a new rule requiring properties to provide 30 days notice of intent to seek eviction for non-payment. So this is different than an eviction notice. This is a notice that needs to go out before you seek an eviction notice. The published document is 2024-28861, or for those of you checking the Federal Register, it's 89 FR 101270. The easiest way to find it is to go to the Federal Register page, federalregister.gov, and search for 2024-28861. It applies to pretty much all of the properties that we're talking about when we're talking about project-based. Section 8, the PBRAs, the project-based rental assistance. Section 202 and 162 PACs, project assistance contracts. Section 202 and 811 PRACs, the project rental assistance contracts. Section 811 PRAs, or project rental assistance, and the senior preservation rental assistance contracts, or the SPRACs. All of those are covered by this notice. The compliance deadline for this is January 13th, 2025. So you should already be aware of and using this notice. The lease deadline, though, the change to actual provisions of the lease, varies based on when HUD gets that new lease out and whether you're public housing or project-based housing. So HUD is looking to avoid evictions where we can find a solution. They're looking to preserve housing for people. We all know there's a shortage of housing out there, and if somebody ends up evicted from housing, they may not get housing again. And evictions are time consuming and extremely costly for the owner agent. So finding a solution that doesn't involve an eviction helps everyone. Elements of the notice. So what's in this? Well, you need to be telling tenants how they can cure the violation, so cure the non-payment, how they can request reconsideration of their income, and how they can request a hardship exemption. You also need to provide them with information on what options may be available if there's a declared disaster. When you're telling them what their arrearage is, HUD requires you to provide an itemized list separated by month of the rent that they owe and any other charges that are allowed by HUD and included in the lease, for instance, late fees. That has to be listed separately from the rent. So you're going to list April, May, and June's rent, April, May, and June's late fees. They also need to be given a deadline by which to pay or make arrangements. And that's the deadline by which their failure to do what they need to do is going to result in the property management seeking eviction. So how do they cure a non-payment issue? Well, they're going to either pay the arrearage or they're going to make satisfactory payment arrangements by the deadline. If they do those, the violation is considered cured and you can no longer seek eviction for that particular violation. If, however, you make a payment arrangement with them and they then don't stick to that payment arrangement, then you're going to consult with your attorney. We have to make sure we give that notice to tenants at least 30 days before initiating any action to terminate the lease. So different states have different requirements for how much notice you need to give in, say, a notice to quit. This comes before that. So this needs to happen before you make any steps to terminate the lease. So it's not the same as any notice to quit or state required notice or notice to cure. You're going to seek legal advice if you're not sure as to whether this would also meet state requirements. Those are very individual to the states. So you definitely want to check that with an attorney if you are looking to find out whether this also meets another requirement. Remember that 30 days is the minimum. You are permitted to give them more notice than 30 days. So if you wanted to give 45 days, you're welcome to do that. You have to at least give 30 days. HUD talks a little bit about how that should be delivered or what it should look like. It needs to be provided in an accessible format. So be aware of people with limited English proficiency. If you know that someone does not read English well, you're going to look to provide that in a format that they can read. And be aware of anybody that has visual disabilities who may need the notice provided in an accessible format. HUD suggests including information on how they can request a reasonable accommodation and who they should contact. We would also suggest including that VAWA notice as well in case the non-payment is due to a VAWA concern. It gives them another chance to come and talk to you if there's a VAWA-related issue. HUD does not specifically state what method you should use to deliver that. We would suggest you use something that allows you to confirm that they received it and document that should you need it later. Certified or registered mail, hand delivery following any guidance from the state or your attorney as to what constitutes documentable hand delivery, or delivery confirmation. Something that allows you to say, we handed that notice to the resident on X date, and be careful as to any state requirements that it be handed to an adult in the household or a leaseholder. But those are going to vary by state, so you want to check that with your attorney. Remember that this notice that they're talking about only applies to non-payment of rent. Doesn't change any requirements for evictions for nuisances, disturbance of others, drug use, abandonment of the unit. This notice requirement is specifically about non-payment of rent. So that's going to wrap up this Tuesday tip. Please let us know what you'd like to see on the next one. You can contact us at the email on the screen now or through the website. And we'll see you on the next Tuesday tip.